We are ready.
Good morning. Yes, I'm also ready to proceed.
Thank you, my lady. We are ready. I will place the matter on record. As the court pleases, this is a matter between the Special Investigating Unit and Mr. PHILLEMON LETWABA and 23 others, case number GP07 of 2022, appearing in the Special Tribunal of South Africa before Madam Justice Mudiva, 2nd March 2023. My lady.
Thank you. Council may place themselves on record.
Thank you, my lady. Tom Bukaba, together with Mr. Donald Sikwakwing for the applicant.
Zelma Kriel, Your Ladyship, on behalf of the respondents, number 1 to 21, and I'm instructed by Mashibani Kriel Incorporated.
Yes.
May we start, my lady?
But yes, you may start.
Thank you, my lady. My lady, I'm going to be precise and concise because the issue is fairly crisp.
1 to 21.
Let me start by outlining this, that by order dated 16 September 2022, this special tribunal interdicted and restrained Liberty Life Group from making any payment to the first respondent or any other party in respect of the first respondent's pension benefits. That order was granted pending the outcome of proceedings to be instituted by the SIU within a period of 60 days of the grant of the order. It is common cause that pursuant to that order, the SIU, through Ms. Stella Zondi, issued and filed summons and particulars of claim on 16 November 2022. That is within the 60 days prescribed. What the summons reflect, if I may start there, my lady, at page, which you find at page 001.5 up to 25. Sorry, my lady. Or 231. Yes, my lady, at page 31. Your ladyship will, yes, will see that those summons at the very last page of the summons, there's a name there at the bottom, S. Zondi, attorney with right of appearance as required by Rule 18 of the Uniform Rules, read with Section 25(3) and 114 of the Legal Practice Act, 28 of 2014 as amended, previously in terms of Section 4(2) of the Right of Appearance Act, now repealed. The only issue with that is that it was not signed. However, what appears there is that Ms. Zondi is an attorney with the right of appearance as prescribed. Following that, my lady, on or about 5 December 2022, the respondents issued a Rule 33 notice in terms of the rules of the tribunal, raising the issue that the plaintiff's particulars of claim did not comply with the requirements of Rule 13 of the tribunal rules, read together with Rule 18 of the Uniform Rules, in that the particulars of claim were not signed by an advocate or an attorney with the right of appearance. That's the contention. That notice went further, my lady, and called upon the applicant to withdraw the summons and particulars of claim. It is clear what the respondents wanted to achieve with that. And I'll come to that briefly later on. Subsequent to the filing of that Rule 33 notice, Ms. Stella Zondi corrected and cured the defect or irregularity by signing the issued summons and particulars of claim on 12 December 2022. I think they are from page 0015 to 68. Yes. That's the summons, and from page 0015-76 to 107. And that was followed by a second Rule 33 notice issued by the respondent. Before this tribunal is now an application for condonation for non-compliance with the provisions of Rule 13 of the conduct of proceedings in the special tribunals, read together with Rule 18 of the Uniform Rules. I'm sure your ladyship have had sight to the application itself. It's at 001.5-3-222. And the circumstances surrounding the non-compliance with the requirements of Rule 13 are set out in the affidavit of Ms. Zondi, the applicant's attorney of record. Broadly, there are three grounds for condonation for non-compliance with Rule 13. First, that the particulars of claim were filed inadvertently without Mrs. Zondi's signature, that being a result of some heavy workload at the time. That's the first ground. Second, that there is hardly any prejudice to the respondents. And third, that it is in the interest of justice that condonation be granted by the special tribunal, given the nature and scale of the allegations and claim against the respondents. In response, the respondents have brought a counter application against the applicant, contending that the summons and particulars of claim are a nullity and stand to be struck off. That's at page 001.7-2-20 to 27. I think. However, disturbingly, whilst the condonation application and the counter application was still pending before this court, before this honorable tribunal, and in utter contempt of the proceedings of this tribunal, my lady, the attorneys of record for the respondents addressed a letter to Liberty Group Limited on 21st February 2023. If I may take your ladyship to that document.
You don't need to do that. You can just continue addressing me.
Yes. Where they claim that, and this is what they say to Liberty Life, that the applicant was ordered by this special tribunal to file its particulars of claim and summons on a particular date in December, and that the applicant had failed to do so. And that in the light of that, the interdict in terms of the order of this honorable tribunal had lapsed, and that they requested Liberty Life to immediately make payment to the first respondent. Lady, I submit that that is a, and I say this with all due respect, deception. And that's in contempt of the proceedings of this tribunal. There can be no excuse for that, particularly coming from the legal representatives, and will urge your ladyship to censure the conduct of the respondent's attorneys of record, together with the first respondent. I now want to move to the nullity point contended for by the respondents, that the particulars of claim are therefore a nullity. My lady, failure to sign summons in compliance with Rule 13 of the Tribunal or Rule 18 of Uniform Rules does not render the summons a nullity. It is, of course, an irregularity or defect that can be condoned by the court, or in this instance, the special tribunal, in the exercise of its discretion. And in this instance, it would be in terms of Rule 14. And that's clear from the judgment in our heads, my lady, the judgment of Kumalo versus Nedbank. Of course, my lady, that discretion is to be exercised judicially upon consideration of all the facts. It is a matter of fairness to all the parties. What is significant in this matter is that the respondents do not raise any issue of prejudice. Nowhere in their papers do they raise an issue of prejudice if the defect was to be condoned. The best that they could do was to misinterpret the law. It is only when there is prejudice, and this is the general court's approach, it's only when there's prejudice to the other party that a formal approach to pleadings may be adopted. We have referred to two judgments in particular: the judgment in Trans-African Insurance versus Maluleke, and the judgment in Bertz versus the Minister of Justice and Correctional Services. Those two judgments are to be found at paragraph 35 of our heads. Given that no issue of prejudice is raised by the first respondent or any other respondent for that matter in the issuing and filing of the papers, that cannot be fatal and can be condoned in the discretion of this court. And in fact, we submit the respondent cannot claim any prejudice when they are facing such serious allegations and claim of embezzlement of public funds, because that will be tantamount to an attempt to protect the proceeds of their misdoings. So that the proper remedy or proper approach, non-compliance with 18.1 of the Uniform Rules or Rule 18 of this tribunal, is to apply for an order condoning the non-compliance. That's also clear from the Kumalo versus Nedbank judgment at paragraphs 33 and 34. I will submit that on a proper assessment of the facts set out in the affidavit of Ms. Zondi, a case has been made out for condemnation. And after all, the non-compliance is so trivial that it will not in any way prejudice any of the respondents. Therefore, as that condemnation be granted against the respondents. Any questions?
Are you going to deal with the other issues, Mr. Ogama? Or how do you're on the floor, you might as well deal with all the issues.
Yes, the main one, that's the main issue, but they raised also the issue of prescription.
Yes, that's where I'm going, yeah.
Oh, yes. In the context of these matters,
hello,
the SIU would only have become aware of the misdeeds once it's prepared its report. And in any event, in such matters which involved, amongst others, fraud, the issue of prescription does not arise.
that was?
But in any event, the matters have not prescribed, given the fact that it was only after the SIU could compile its report that they can be aware of the misdeeds of the respondents.
Hey, I can't work on this.
I'm trying to think of the other issue, my lady.
Is it proper to deal with the prescription point at this stage of the proceeding?
Normally, they should plead it when they plead to
It should be pleaded at the right time.
the proper, yes. They haven't pleaded any case before this tribunal, my lady. They also claim, this the other point, that the summons that were reserved were incomplete. That's factually incorrect, my lady. The summons were complete and signed by Mr. Lazondi.
But she didn't attach the annex. She didn't attach the annexes. Because she says the annexes were attached to the defective
The original summons, my lady. And in a submission, that cannot constitute any defect. Because the summons were there, originally served. They were not withdrawn, the original ones. They haven't been withdrawn still. They still contain those annexures. The applicant, or Ms. Zondi, could just as well even serve the last page of the summons in the particulars of claim to cure the defect.
I don't agree with that. I don't agree.
In any event, she filed the whole document, but the annexures were there with the original documents.
So in the event that I grant condonation, don't you think it's proper that I order her to file the full set of summons?
That will be in order, madam. That will be in order.
Thank you, Ms. Kroll.
Thank you, madam.
As the court pleases, my lady, let me start off by putting on record that from the papers filed before you in this application, it was never said that the summons served constituted a nullity. The submission of the respondents in this regard is to the effect that the applicant in this matter served, as we know, on the 21st of November 2022, and a defective summons, as it was not signed. The particulars of the claim was not signed as required in terms of Rule 13, read with Uniform Rule 18, and then they applied Stelbel. The procedure which should have been for them to have brought an application for an amendment of the pleadings in order to affix the signature to the particulars of claim. The fact that the first summons was served with an unsigned certificate affixed to the summons does not take this matter any further. It still constitutes non-compliance. The signed certificate should be attached to the particulars of claim. For my learned friend to say that this is not an important default or defect, that can never be the position. If I can refer you in that regard to the matter of Motswai versus Road Accident Fund, it is in my heads of argument in paragraph 7.5. There in the Honourable Madam Justice Satchel started off in paragraph 30 by saying that the requirement of signature of particulars of claim reflects the importance of both the document and signature. So to make the averment or to the submission to you today that this is not a serious non-compliance, I respectfully submit not. And beside that, as we know that should the respondents be so inclined, they might approach the court seeking for a de bonis proprius cost order. In that event, it is required for the attorney to have affixed her signature, in this instance, Ms. Zondi, to the particulars of claim so that the responsible attorney with right of appearance can be properly identified. And the prejudice for the respondents lie results in the fact that they will not be able to then identify the attorney who was responsible for that. But besides that, it remains that the signature and the particulars of claim reflects the importance of both the document and the signature. And Rule 13, read with uniform Rule 18, confirms, it's confirmed there that it is of importance. So now to come here and say, well, that's not important, and the respondents will not be prejudiced by that, I respectfully submit that cannot. So if we take a look at what transpired in this matter, it is the first instance it was signed with no signature. I don't say that the summons is a nullity because of that. What should have transpired is the applicant should have brought an application for the amendment of its particulars of
Okay,
claim.
we are here now. They are seeking condonation. Why should I not condone the non-compliance and order them to file a signed full set of summons?
My lady, the problem that I don't have a problem with that, because Rule 14 empowers you to grant condonation on good grounds. So if that, my problem, and the reason why this application was opposed is because of the improper or inadequate relief sought in the notice of motion. If you add the rider saying that the signature must be affixed to the particulars of claim, and the full service is not then required, because I mean, if they amend their papers following your order in terms thereof, then I submit, then the papers will be in order. I refer
Okay, so
you.
if I grant an order condoning the non-compliance and ordering them to file a properly signed full set of summons, then that accommodates you. Then
My lady,
no prejudice to you.
it will. My lady, I think I cannot fault your proposition, but what I would suggest rather is for them to find a notice of amendment to amend their pleadings.
No, but to what end? What's that gonna? Remember, in the tribunal, proceedings should not be unduly prolonged. Hence, I'm saying to you, we are here now. Why do you want to insist on them following a very laborious amendment process when I can simply order them
My lady,
to comply with the tribunal rules?
my lady, this is your court and we're in your hands. If you feel comfortable with doing that, then that is the condonation that you grant. But what I say is the application as it stands, the relief sought is insufficient and inadequate. It will not solve the problem.
Yeah, but I can grant under the rubric further and alternative relief. I can ensure that the defects are properly addressed.
Indeed, so, my lady.
In the
Indeed,
interest
so.
of expediting the trial.
We are in agreement that you have the authority to do so in terms of Rule 14.
Okay, and then the prescription point, the proper place to raise that is in a special plea.
As the court pleases, man.
Premature to raise it at this point, right?
My lady, regarding the fact that the applicant did not indicate its prospects of success, it's my submission that the prospects of success is an issue that must be considered, because if there is no prospect of the matter succeeding on trial, then there's no reason to revive or to rectify a faulty pleading. So in that manner, I cannot agree with the submission of my learned friend that the prescription is not of relevance. But I will not argue that persist with the issue regarding prescription. What I want to persist with is the fact that the applicant is obliged in its founding affidavit to have indicated to you what its prospects of success are. My lady, there is no prospect of success premised on the submissions contained in the founding affidavit. There's no course of action set out there. There's a list of they having explained to you what transactions money came in and money came out. And then there is a very vague submission, if I can just find it, in paragraph 16.4, the SIUs of the firm view that based on the evidence in its possession, so it's not before the court, we don't know what it is, Mr. Letwaba and a number of the other respondents and entities may be guilty of corruption. My lady, that doesn't take us any further. We must be able to ascertain from the founding affidavit what the prospects of success are. This cannot found any prospect of success. So if it lacks, then how can you then make a decision to say, yes, we must rectify this faulty pleading because there is a chance of the matter proceeding to trial and to be successfully finalized. There are no facts before you indicating that, but that certain transactions, monies went in and monies came out, and to whom and the amounts thereof. That's the only evidence there is before you to indicate success. So in lack thereof,
isn't that set out in the preservation application? It's part of the same proceedings. Can't I have regard to that?
My lady,
this is an important matter in the public interest. I don't think I should ignore all that evidence because it is before me.
My lady, it's not
in fact,
before you.
I granted the preservation application, so I'm aware of all those allegations.
My lady, it's not before you. They could have incorporated that. They could have done that. They did not do
Anything
so.
further? Anything further?
Yes, my lady, as to the aspect of costs, there was no need for us to have convened this meeting this morning. If the applicant, as it prudently should have done, amended its pleadings in terms of Rule 15, this matter would have been finalized by now and the respondents could have pleaded by now. They elected to approach you and to rather have it get an order from you as opposed to us not being here, us not preparing papers. So in that regard, it is my firm submission that the applicant should pay the costs hereof. There was no need.
Of course they would. Of course they should. They're seeking an indulgence. Of course they should pay the costs.
And that's my second point, my lady. They should pay the costs. They're seeking an indulgence and they are liable to make payment of the costs.
Okay. Anything further?
I need. Can I just give for my attorney? No, nothing further, my lady.
Thank you, Mr. Bukaba.
Thank you, my lady. My lady, there's clearly no basis for the respondents to have opposed this application. In fact, they did not succeed on any.
But you wouldn't have come if they didn't insist, if they didn't put the SIU under pressure to ensure that the proper procedural rules are followed, then you would not have approached the tribunal because you had taken defective steps to remedy the defects in the summons. And that's why we're here, really.
Yes, my lady, but
even I'm not happy with the way the defects in the summons were corrected. I'm not happy with that.
That might be so, my lady, but they haven't shown any prejudice, which is a requirement.
Okay, so it's very clear I'm going to grant the condonation application. It's very clear I'm going to order the SIU to file a full set of signed summons. I intend ordering them to pay the costs on a party scale because they are seeking an indulgence. And then the prescription point, I'll order that it's a special plea should be filed. Anything further?
As your ladyship pleases.
As the court pleases, my lady, nothing further.
Did you did you file a draft order, Mr. Bukaba? You may need to amend it to address the
All
issues.
those.
It should reflect the terms of the order that I've indicated.
That will be so, Mali. I'll ask Mr. Sikwakweng to work on that immediately.
As soon as possible, please.
Thank you, Mali.
Thank you. Proceeding, Sergeant.
As the court pleases.